Okay, so I believe this is where we were at. We talked about the right to privacy right at the conclusion of our Tuesday class. Now again, if you didn't have time to mark that down or you need a refresher, I'm going to see what this chat real quick. So yeah, we looked at the zone of privacy, that idea put forth initially in Griswold versus Connecticut, that everybody enjoys that protection from government interference in your private affairs. We had talked about the two fields in which that kind of comes into play, and that's in abortion policy, the right of women to have the procedure, and in terms of LGBT politics. So over the course of the last, 70 minutes or so, we're going to touch upon those, and then we're going to get into the discussion of your rights as you go through the arrest, trial, and so on and so forth phases of criminal justice. Roe versus Wade is the first case to set up a precedent, the legal interpretation. Yes? I can try, yeah, sure. Roe versus Wade says that the woman's right to have an abortion shall not be impinged, really, that is a zone of privacy issue, that the government cannot get involved in those affairs. If you look back at the early 20th century, there are a lot of illegal abortions going on. The state by state legality of abortion varies pretty considerably. The Supreme Court has to weigh in upon this decision or these decisions to ultimately go forth and make an equal standard for women across all of the states. What we need to look at when it comes to abortion precedent is that the widest or most broad rights the women have in the procedure start off at the beginning. And in the last 50 years or so, they've been winnowed down. They've been reduced bit by bit. We're going to talk about how that evolves. So when you look at abortion policy, you look at Roe versus Wade providing the initial grant of kind of this power for women, and the Planned Parenthood precedent giving the states a power to shape the policy. The Supreme Court time and time again has to consider both of these cases. So Roe versus Wade in the 70s, the Planned Parenthood versus Casey case in 1990. Any sort of decision regarding abortion has to take both of those cases into consideration. It's not only one or the other. Yes?
Could these have been used for the paper proposal, like those cases?
For sure. Yeah, if you talk about abortion, I really want you to talk about these cases. They are the foundational ones when we're looking at abortion policy. If you want to talk about women's rights as a general thing, you probably at least want to talk about Roe versus Wade as well. So yeah, any of these cases we talk about, please utilize them if they match with what you're looking to focus on for your paper proposal, your final paper, whatever. So what the second precedent is, the second bit of legal reasoning with Planned Parenthood versus Casey, it says that states can go and shape a woman's right to have these procedures. So as long as the state themselves aren't saying that you cannot have the procedure kind of a blanket ban, the state is allowed saying we can stop women from having, say, a partial birth abortion, the second precedent, or abortions at different times, different trimesters. So there is obviously in a great number of states a ban on women having abortions in the third trimester, the last one where the fetus is viable. State legislatures have said, we don't want this to happen. The infant could essentially grow and thrive. It's very dangerous for the women. We're going to put a bit of code, a law on our books saying you cannot have it after 36 weeks, or 24, or 12, or 10. That's all been shaped in the years since using the Planned Parenthood case. The idea here is that women still have the ability to get the abortion procedure. You're not saying no, you're saying no after a point. There's been other ways that the state legislatures have tried to decrease the potential of women to have abortions. So the partial birth abortion, the Gonzalez case, that's another one that gets challenged. Again, the woman's right to have the procedure, it might be decreased, but it's not removed. There's been some challenges about how far exactly you can cut down the frame, the time period in which women can have an abortion. So some states are 12 weeks or 16 weeks. After that, you cannot get the procedure. States, or especially those in more conservative areas, the more moralistic sort of political cultures that are present, have pushed that number. They try to put it down to 10 weeks or 6 weeks. And without this becoming too much of a biological class, even though we're in the science building, the idea with this is it's difficult for women to understand when they're pregnant if the whole time frame with the period is such that a missed period is kind of due to a lot of things, not necessarily pregnancy. So there's a lot of issues that come forth with a place like the Supreme Court. At what point is it for the safety and health of the mother? At what point is that where legislators in that state just don't want abortion to happen at all? So lots of issues in regards to this. There's been cases that have been brought up just down the road. Shreveport has an abortion provider. It's the Hope Medical Center. And there was issues at play with regards to another approach taken by the legislative side at the states. This is in regard to admitting privileges or size of the actual clinic requirements. So what had happened with this, and this is kind of current abortion procedure, kind of the Supreme Court's going to be probably taking this more and more into consideration in the years to come. Some states have required that the physician that's kind of in charge of the facilities have admitting privileges at a hospital with a certain level of care. So I'm sure you're familiar, there's various trauma centers, you have level 1, 2, 3, level 3, I think it's for the worst, most severe sort of accidents and things that happen. Some states would have it that you need to have admitting privileges as a physician at a level 3 trauma center. That seems fine and dandy. The idea here is, what if something goes absolutely wrong? You need to bring the woman in to get emergency medical care. I mean, it seems at the sniff test to work out. The problem is, and this idea of women having their right to have an abortion comes in the fact that if we're in a state like Arkansas, there might only be 1 or 2 level 3 trauma centers within 150 miles of, say, a rural women's health center. So you can imagine a center over in Stamps, or, yeah, let's use Stamps, for example. If the idea here is that you need to have admitting privileges, that might mean you have to have those up in Little Rock. It's not going to be very possible, or something that a physician's even going to want to do, to have admitting privileges at a place 100 plus miles up the road. They're probably going to have admitting privileges in Magnolia, but based on this proposed piece of legislation for Arkansas, that's not going to cut it. You can't be properly registered as an abortion care provider if you just have admitting privileges at, say, a level 1 trauma center or something like a normal country hospital. Other issues that come into play are size of the clinic. There's various square footage requirements that states have tried to implement in regards to abortion providers. And the idea here is that you need a goodly amount of space for this to be done. Now, again, without getting into the biology of it, a lot of the procedures don't require a ton of space. If this is something that's done through taking a pill, if this is something done through a vacuum aspiration, you don't need a huge center. You don't need a huge batch of rooms for care. And the idea here is, are states acting in bad faith to remove the possibility of women to get abortions? The idea here, if you need to get a 10,000-foot office complex, that's going to be cost prohibitive, especially for those places like we talked about, the more rural providers. So lots of undecided issues when it comes to abortion policy that the Supreme Court will likely have to weigh in upon. There's other cases that you can look at, Whole Woman's Health versus Kellerstadt, if you're writing about abortion policy. Another thing to think about when it comes to this, and pretty much any other type of precedent the Supreme Court weighs in upon, is the composition of the court. Who's actually sitting there? Now, we're not going to talk a ton about this because we're not in the judiciary chapter yet, but the simple fact is the Supreme Court, comprised of 9 people, largely share the ideology of the person that proposes that they sit in that seat, that actually is offered up as an appointee. So if you're an Obama, you're probably going to have more liberal individuals. The idea is that the court's supposed to be above that. That's really not how it operates. We can see the same sort of thing happens with Trump. Trump has more ideologically conservative sort of viewpoints when he puts people forth like Kavanaugh. So when it comes to an issue like abortion, which is kind of fueled by that ideological divide, the composition of the court matters a lot. So it's important for our current sort of discussion because there's a member, and has anybody heard of Ruth Bader Ginsburg? A few of you. Okay, so she is an individual that's of advanced age. She's, I think, 85 or 87. She's had a issue, kind of a resilient sort of cancer that's been going through her for a while. The idea here is that she is part of a more liberal minority of the court, with about 4 people that reliably support the right of women to have abortions. You typically have Chief Roberts, who's a more conservative person, come forth to make 5-4 protections for abortion. The idea here is if she steps down, Trump's going to have another appointee put in. And that 4-person minority is going to drop to a 3-person one. That might only change that precedent with regards to Roe versus Wade. So kind of fascinating as we talk about these discussions here in the future. What is likely going to happen? She's still doing okay. She's still sitting in her seat, even if she's not always physically in the court. But if anything happens, we'll update. All right, so the next part of our discussion, this is consensual sex between adults. This is what has traditionally been called sodomy laws. So we have to go back in time just a bit to the 1980s and before. So when it comes to homosexuality, it was actually seen as a mental disorder, DSM-3 and maybe even 4, maybe not 4, but those psychological manuals identified it as a disorder, as a mental issue. As a result, with that being kind of a more social idea, the Supreme Court has traditionally deferred to the rights of the states in setting up these standards for behavior like sexual activity. And in fact, in the 1980s, there's this Bowers versus Hardwick case. The Supreme Court ultimately says that for homosexual sexual activity, again, all other things being legal, like consensual of age, those are always the requirements here, right? We notice that the zone of privacy doesn't actually work. That argument does not hold water in the 1980s. The general presumption of a lot of individuals at this time is that it's either a choice or just this, again, mental issue. However, the standard changes, and this might be part of the overall zeitgeist, the spirit of the times, part of this evolved way of thinking that it's like an inborn thing as opposed to like a socialized decision sort of thing. That we have another Supreme Court case that comes in with Lawrence versus Texas. Now, a bit of personal information. So obviously I did my undergraduate. I did my undergraduate in rural Indiana. And there was a group I worked with. I was actually treasurer for the LGBT group on campus. They handed out little sheets of paper that had the 50 United States with different colors based on what sort of criminal acts the sodomy would really entail, this sexual activity. So in some states, it was absolutely okay. Whoever you hooked up with, whoever you hooked up with. Some, it was prison time if you were caught doing something with the same sex. So it's pretty shocking. By the time we got to 2003, though, Supreme Court weighs in upon this. The idea here is that there's not equal protection for LGBT Americans throughout all 50 states. Again, like I said with that map, just based on where you ended up laying your head for the night and who you hooked up with, it could be something that's completely ignored, or you could be in jail for an extended length of time. So what's the case facts of this specific case? Ultimately is that there is an apartment complex, a big building. A fire starts on the one side of the building. There's firefighters and law enforcement that are going and knocking on doors and saying, hey, get out, there's a fire. At some point, law enforcement comes into one of the apartments, finds two guys in a very state of undress. I mean, it's obvious that there was sexual activity going on. I don't know where in the act of coitus they were at, but something like that occurs. Based on what Texas had on the books at that time, it was illegal for those people to do that act, and they get arrested as a part of that. It wasn't that they were being too loud. It wasn't that they were in eye shot of little kids or anything like that. It was just purely the fact that there was a fire and the police were doing public safety sort of things. They have an argument with regards to their arrest. They challenge their arrest legally. The Supreme Court of Texas, it gets appealed up. They get to argue it upwards that the arrest was not constitutional. And the Supreme Court of Texas says it's absolutely fine to have this standard. It's absolutely within the right of the state to police morality. And again, without getting too far into what the Supreme Court can do, the Supreme Court can take cases at the state level and take them on up to the national level when there's a matter of this kind of different standard held for individuals between different states. And like I said, just based on where you're laying your head that night, it meant that there was different standards, right? The Supreme Court ultimately weighs in and has a different opinion. They overturn the Texas decision. They say, that's not correct legal reasoning. You didn't do this in the right fashion. And again, it utilizes the precedent that Griswold versus Connecticut laid out. That again, the people have the ability, when it comes to their own personal affairs, to not have the government be involved in those personal affairs. And I've got the actual opinion, the legal reasoning that the majority of the Supreme Court signed off on. This is how any sort of subsequent law that deals with this has to consider. I've got the quote here. It's not important that you write it down, but just to listen and consider how they interpreted it. The petitioners, these are the people that were arrested, are entitled to respect for their private lives, that zone of privacy discussion. The state cannot demean their existence or control their destiny, so if they go to jail for the night, by making their private sexual conduct a crime. Again, we see the privacy be a part of that. It's absolutely within the police power of a locality, a state, what have you, that if you hook up with somebody in public, you get arrested for public indecency. But again, when you've got those curtains covered, you've got those doors closed, as long as there's consent, as long as it's of age, the state cannot be involved. So that is an important change in the precedent. Showcases the precedent as existed in the 1980s, and then ultimately what the current precedent is today. We do notice that there are still different legal realities for LGBT Americans. We'll talk more about those with the 5th chapter, but in terms of wills, like who ultimately gets things, that legal sort of standard, does it go to the children made of a heterosexual union that occurred before, say, a homosexual marriage, or the person that they were actively with when they died? That sort of discussion has not really been solved to any sort of degree. But we'll talk more about that as the time comes. Okay, another one of these that's not going to be something you need to copy down, just to showcase how different your rights are than what are provided by the actual Bill of Rights. We'll talk about issues of searching and seizing, how the various police authorities at the state, local, and national levels have more than the powers you'd imagine that they have based on the Fourth Amendment. We'll see self-incrimination is pretty close to what's actually provided. See, double jeopardy is about the same thing. We'll talk about the issues of due process, your like legal protections in the court system, how they might be different if you are an enemy combatant. We'll talk about why that was an issue back during our time with the Iraq and Afghanistan wars. We'll see this cruel and unusual punishment, what this actually means, the Eighth Amendment. That'll be a fun discussion to have. But just a second to cool down before we get back into the heady stuff. All right, so rights of the people that are accused. A few things here. I'm going to try to keep this up as much as I can. Big sort of discussion is when it comes to actual legal procedure, from being detained, from being arrested, from being accused, out to being in court, to being actually adjudicated, found guilty, found innocent. There are certain baked-in protections that you and I have. Those are those inherent powers that we have, those ones that are inalienable, not able to be taken away by the government. So we need to know procedural due process as kind of a definition. But it's just those protections we have under the Bill of Rights. And we'll often see that these are the Fourth Amendment rights, Fifth Amendment rights, Sixth, and then Eighth Amendment rights. So that's a batch of the amendments that roughly provide the rights that you have should you happen to be through the court system. We'll talk about the different sort of police searches that exist. There are a lot of exceptions or exemptions, alternatively used based on the textbook. So police typically have to have a warrant for seizures, for searches, all of these sorts of things. We'll see those specific areas in which that's not required. There's one case that I do want to talk about just briefly, Wren versus US. So this is a thing that anybody can be picked up for. The idea here is that you driving around the city, the police have a slew of different ways they can pick you up on fairly normal sort of infractions, right? So if you don't stop for a second when you get to a stop sign, when you don't go and take 1, 2, 3 or something like that, you might do a rolling stop. A police officer could pull you over. When I first got down here to Magnolia, I was pulled over by a police officer because I had my car dealership's plate, you know, the one they give you has the name of the dealership. It was obscuring too much of my license plate. So you got that. You've got various times when you don't signal. If you turn left off a four-way stop, you just do it. All these things in which police officers can stop you, right? Pretty normal sorts of things. You're not doing anything crazy. You're not driving drunk. You haven't run into anybody. The idea with a case like Wren versus United States identifies that if the police officer finds something illegal, that when they're walking, say, to the side of your car, to the passenger side of the car, they look on in, they can bring that into actual evidence in a case against you. So what I mean here is, again, you do just very mundane sort of traffic infraction. Perhaps you're not paying attention. You're on your phone and you blast through a stop sign. I'm sure most of us have done something like that. Hopefully not, but reality of the situation indicates it probably happened. Well, imagine it's Labor Day. And I know not all of you are over the age of 21. Perhaps you have one of your buddies that's over the age of 21 that's got you a Handle whiskey or whatever you like drinking. Hopefully you don't drink unless you're 21, but again, reality of the situation, right? If the police officer stops you for something very plain, sees that you are in possession, it's pretty obvious you're the only person in the car, there's a handle there, you shouldn't be having alcohol under the age of 21, that could be brought into evidence against you. Now, your infraction in no way was related to what they're charging you with. And you can imagine there's not a direct line of correlation. Doesn't matter here. This is that plain sight admissibility of evidence. So that's one of those sorts of things. If you decide to buck the law, make sure stuff's hidden. But again, if that's in plain sight, if you, I don't know, you've got criminal tools and they find you, even though there's not a direct sort of way, you're driving criminal tools, like you have, I don't know, a crowbar or something like that. There was something like a garage broken into down the road from where you're driving. That could be brought into a criminal case against you for breaking into that garage, even though it was a driving offense versus a breaking and entering sort of offense, a robbery or theft sort of offense. And excuse me for saying that, there's a difference between robbery and theft legally, just to be clear. If you're interested in anything like that, our American constitutional law class goes into a pretty good amount of discussion beyond what I talked about here. All right, sorry about going through these fast. I'm going to try to add enough examples to keep things nice and slow. There has to be some point during the suspicion phase where the police provide you with a rundown of what you're being charged with. They can't just hold you without letting you know what's happened. So it's this writ of habeas corpus. Essentially, throughout the United States, there's only been one little time that we've not had this protection. President Lincoln suspends the writ of habeas corpus during the Civil War. It's this idea that we need to go and have kind of strong police presence to make sure that we're only fighting one battle. We're only fighting against the South as the North. But yeah, you have to be told exactly what's going on. Now, in terms of current sort of technologies, there have been Supreme Court cases that have weighed in about your own protections, your own rights. So a few cases here, the Riley case, the US versus Worry, they identify that you being arrested, if you've got your phone on you, you still have protections. It's not just simply they can search your pockets, they can search your phone because it's in your pockets. There needs to actually be a warrant. So the police officer, the either arresting officer or the office itself has to go in front of a judge and identify why a cell phone would be crucial, like getting access to it, to understand what this crime is about. So saying that, it behooves you, should you happen to ever make it in front of a police officer, not to open up your phone, especially if you have something that might be kind of problematic. What I always tell students in this class is, when I was driving to Texarkana one time, I don't know how many of you have been out to Texarkana any time in the last little bit, but there's a dead spot with your cell phones where you can't get access. It's about 15, 20 miles outside of Texarkana. What I usually do with my phone is go and have my car insurance app there. I've got it where I get into my app and I've got my little proof of insurance. You can imagine here where it's not something that is to do with car insurance. So there was a public safety stop one night on the road leading back into Magnolia. Every car was being stopped. You had to showcase your form of insurance. Now, if there's a public safety idea, you can imagine here, if I handed over my phone, the police officer could essentially nip through it and look through each maybe message I had. Now, if the idea was public safety, we're trying to find drunk individuals, perhaps that officer would want to go through my last messages and said, okay, is there an idea that this guy was at somebody else's house? Is there a communication saying, hey, go and bring some smoke over or something like that, that I can get a case put forth against that individual for illicit materials? You can voluntarily give up access to your information, and that's perfectly fine. The police officers can take evidence from that if you give consent. So there is, I don't have the name, I've forgotten him. There's an issue with a baseball player that's being arrested for supposedly sexting a 14-year-old girl. And his whole contention was that he was forced into providing access to his computer that had these communications and pictures. But the official police report on this was that he voluntarily gave consent to the police officer to look through and in fact showed the actual pictures of him talking to this girl and her in various states of undress. When this is an issue, if there's a worry about that, the police officer would have to get a warrant. Now, the actual standard to get a warrant isn't too terribly difficult. If there's a good sense that you have been doing an act that is not above board, that is illegal. It's easy enough for the police officer to call up a judge and say, hey, I've got this person that I have a good idea that, I don't know, they're selling illicit drugs. This person's previously been doing this. There was a strong marijuana odor in their car, so on and so forth. It'd be easy enough to get that warrant to get records requisition, but still, you don't need the consent. All right, so roadblocks, that's the next little step of things. Various states have DUI checkpoints or don't. When I was up in Ohio, you would be reported every week where exactly a DUI checkpoint was. So they'd be like, okay, over at the shoe, because I was over in the Columbus, Ohio area, the horseshoe where the Buckeyes play. They'd be like, okay, on High Street, over by the stadium, there's going to be a DUI checkpoint from 7 to 10. It was legal on state law to do that. And it was legal because every single person was checked for sobriety. There was some idea that it would be more than likely a lot of people were drunk, they were tailgating, they're doing whatever. It wasn't that the police had the discretion to stop every person they felt was drunk, but every person was stopped equally. We notice that the Supreme Court affirms that. Now, the Supreme Court does not affirm, does not provide for states stopping people for perhaps possession of drugs. If it's public safety, make sure that roads are safe. That's within the power of the police. Just to get stuff like marijuana off the roads, it's not okay. So the example I'm going to bring up, if you go out towards, what is that? If you go out towards Wichita Falls, Texas, that is going out towards Colorado. Colorado has recreational marijuana. There would be a good idea that if you were over by Wichita Falls, which if you look at the map of Texas, you could drop down to Dallas pretty easily. You as a police department, Wichita Falls, or one of the small areas right around it, probably could go and stop some cars with out-of-state plates, pick up somebody that's ferrying drugs from point A to point B, and have a lot of arrests on your hands. That doesn't pass muster. That is not a constitutional way to do things. It's kind of fascinating in regards to what happens when a state or a law enforcement agency is required to change their behavior. They change the nuance of what's going on. So, okay, you can't just stop people in the hopes that you pick up drugs. However, what happens in places like Pennsylvania is that a law enforcement agency or whatever Department of Transportation put up those signs, you know, the programmable ones, and say, okay, there's a drug checkpoint on exit 10 coming into the state, so 10 miles up the road. You start with exit 1 or 0, whatever have you. Now, the road sign is absolutely false. In no way do they actually have a drug stop because those are not constitutionally legal. Anything arrested from that, the charge won't likely stick. What they can do is go and set a bunch of cops up at exit 9 or whatever the one is right before that and look to see what happens when people are acting furtively in the local, say, gas stations or pull-off spots. They are within their right to do things like that, especially if they're just trying to help out individuals. And should they happen upon somebody that's trying to secret away some contraband like that, well, they can go through a normal process. They can actually go and arrest those people. It's kind of an interesting way. We see a back and forth between what's legal. A state or a law enforcement agency will be told, hey, you can't do this, and they'll kind of pivot to something else entirely. All right, to continue with this, Let's talk about a few different issues here. We're going to talk about drug testing generally. So what happens in a number of various hospitals today is that if there's a good sense the person is drug searching, essentially just trying to go to the hospital to get whatever, get a script of Vicodin or whatever, there will be a drug test given to them. They say, oh, I've hurt my back. I was working on my car all day. I fell over, whatever sort of excuse they want to come up with. Hospitals are allowed testing to make sure that there isn't stuff like illegal drugs, opiates, whatever have you in their system. There is a Supreme Court case, though, in which various state laws concerning the reporting of these drug tests to law enforcement was being challenged. So you can imagine an example of where a drug test of somebody that came in to, say, Magnolia's ER comes back with people popping for opiates or methamphetamine or something they shouldn't have in their system. It would probably be a slam dunk to go and have somebody that's just sitting in a hospital bed, be arrested by the police. It'd be a good way to get some drug addicts off the streets. It's the general perception for why some of these laws existed. An individual's right, essentially, to have healthcare right to privacy in some sort of regard, it protects them from getting that sort of traditional drug test sent out to the local police. There isn't anything saying you can't be arrested if you're getting medical care. If you decide to be bellicose, if you decide to go and steal stuff, any of those things could still get you in on that. But it can't just be an automatic sort of sending of the information. A few years back, a few of you might recall there was a nurse was actually arrested for not providing drug test information of, I think it was a former officer. The local law enforcement was trying to go and invalidate it was like a retired officer on a disability, trying to invalidate his claims by asking for drug test results from when he was up in the hospital. The nurse identified that, hey, I can't provide you these documents. They have protections. And she was actually arrested for going and interfering with police business. That ultimately gets overturned, but we do notice that that is a protection that you have. You can't just be sitting there, you have your reports given out to Magnolia PD, and then you're arrested for being under the influence. However, you do have something slightly different when it comes to children below the age of 18 or people in public high schools. It's absolutely okay to be tested for extracurriculars. That's just one of those that there hasn't been a protection given. It's kind of interesting. You notice that there are a number of different fields in which people that aren't at the age of majority, so aren't adults yet, as based on the law, whatever that is, don't have the same protections that adults have. And this is one of those examples. It would have been nice, as just an aside, I was part of the quiz team back when I was doing high school. And one of my buddies on the quiz team was actually really hard up. He was drinking vodka on a bus to the actual quiz team tournament. So it would have been nice if they would have grabbed him on a drug test and got him into some help beforehand. But that wasn't part of that case yet. I wasn't quite 2002 when I graduated high school. All right, so let's get into this actual arrest phase sort of thing. So if you're looking at the protection against self-incrimination, so you are protected from saying things that would go and showcase your guilt in a specific matter. So ancient history by this time, but there's a hilarious Chappelle show, a skit from back in the day, where he's acting as a character and he says, I plead the fifth, and that's all he ever says. But it's this sort of idea that you have a protection. If you're asked something point blank, you can say, I wish to utilize my Fifth Amendment rights here. So you're not saying, oh, well, I was in that garage that night before I ran off and was apprehended by you, officer. You can just say, I plead the fifth. and then it's not an admission of guilt. I'd mentioned most of you are familiar with your Miranda rights, watching stuff like Live PD or Cops over the years. It's important to recognize that that doesn't need to be given verbatim. That does not need to be given word by word. A lot of you can come up with the whole spiel, but as long as what the rights are accurately communicated to a person, then any sort of evidence that's brought forth after the providing of those rights can be considered in a court case. Now, if you're not given those rights, and I'll put these up here in just a second, then that sort of evidence does not hold water. It can be challenged as a legal fact in the case. And in some examples, you'll actually notice that even if the person is kind of beyond the shadow of a doubt guilty, the fact that the police didn't follow the correct procedures in terms of the evidence meant that they were able to go scot-free. I'll let people finish copying this on up, and then we'll get back to it. All right, so I'm just gonna leave this up. But again, this does not need to be verbatim, but just to communicate as a local law enforcement. You don't need to copy these all down, but anything that they say can and may be used against them in a court of law. So if you actually say things after you're told about these rights, then it can be put forth as a legal fact here, as something that the police officer, somebody in the jail, wherever, can pick up. The right to an attorney present, that is an important understanding, because you can imagine here, you not having an attorney, you might not know when to keep your mouth shut. I mean, you might not know about your Fifth Amendment rights. You might just say, trying to be truthful, that you'll have lesser of a punishment perhaps. You'll say, well, I was there in that garage that night. I was trying to steal some tools to sell at the pawn shop. Well, if you had an attorney present, they might say, well, there's no indicator that you were actually at that garage. You shouldn't say anything of the sort. The other important part here is that you don't need to be flush with cash. The protections that you and I have in terms of courts, kind of this procedural due process, indicates that you should be able to have an attorney appointed to you. So if you are indigent, if you don't have the financial resources of your own to pay for a lawyer's services, the public expense, a public defender, will be able to ultimately go and be appointed to your case and to help you navigate each of these issues. There's a lot of issues with that, though. So we'll talk a bit about this right at the end, but to go a little of a preview. Public defenders' offices are very overworked. So if you are at a private attorney, you pay your retainer, they're going to only have a workable caseload based on what they think they can do. A public defender's office is kind of shunted with anywhere from tens to hundreds to thousands of cases based on how large of an area you're at. So if you're in, say, Maricopa County, a major metropolitan area, you are going to have maybe tens to 50 to 100 cases as a public defender you have to deal with. That becomes problematic when it talks about how you create your legal defense for your client. If you got all the time in the world, you're being paid, you're going to do kind of your best work. If you're forced to only spend maybe an hour a week on working on somebody's case, you can't really give your best work. You kind of just try to make do. So there's some issues with people that are getting public defenders. Well, oftentimes will be told to plea out, to get a plea bargain, to plead guilty to a lesser offense because it's easier on the public defender. And it's a lesser offense than being, say, murder to assault with grievous bodily harm. The simple fact is that person might not have done something like that, but is told to go and plead to that. The quality of legal care might be different as well. So if you're somebody that is paying for the services of a person in a firm, they're going to be good enough to work at that firm. They're going to be hired into that position. individuals that are over at the public defender's office, oftentimes, not every time, it might just be kind of doing pro bono or for free work, oftentimes are younger sort of lawyers that really haven't gotten a name for themselves yet. And to be absolutely frank, might not be of a quality that is a firm level. They might just not be as good as somebody that's immediately snapped up by a private law firm. So lots of problems with this protection. You have the ability to get a lawyer for free. You might not get a quality of legal representation with those people that are pretty flush. And then we can get into all these issues with disparate sentencing, disparate wealth rates, say between white Americans and African Americans. But let's go into a few of these smaller rights, getting kind of close to the end here for this discussion. Okay, so instead of copying stuff all the way down, we need to know another Fifth Amendment right. There are various court cases in which a single judge can decide your fate, or a bank of judges, like 3, 5, 7 judges. When it comes to a federal crime, not a protection at the state level, that's not been incorporated to us with that selective incorporation, but at a federal crime, there's a protection that we have with procedural due process that indicates you should have a grand jury, essentially a jury of your peers. The idea is that they should represent you in terms of race, in terms of age, education, and income. They might be able to have a more kind ear than somebody just sitting as a judge. Again, this is an interesting example of that selective incorporation discussion that we've had. There's not been a Supreme Court case yet that has indicated the need for a grand jury at state level crimes. So if it's one of those crimes that you've done purely within the state, if you get arrested for embezzlement, if you get arrested for, say, a murder charge, and there's no indicator that you've crossed over state lines, your embezzlement isn't for a company that has multiple locations throughout the United States, you might just be under the determination of a single person, a judge. The discussions that we've had in terms of the Miranda rights are a case here, the Johnson case. And then later with Gideon versus Wainwright, talks about the need for actually having legal representation. Again, talks about the definition of indigency, essentially that you just don't have the cash to pay for it. And that has been incorporated both at the federal level and the state level. The Johnson case in 1938 is the one that says you've got this protection at federal level. But again, when you look at most court cases, they're done at the state level. That wasn't a big baked-in protection until 25 years later. This Gideon versus Wainwright case had to come on down. Gideon ends up, he is somebody, I think he is arrested for theft in a pool hall or something like that. And being in just a single pool hall is like essentially a bar. You're not going to have that be a federal crime. That's just going to be done at the local area. This is just put through the Florida courts at the time. He gets arrested. He isn't required to have any sort of legal representation. He's not able to really create a good legal defense for the reasons why he was supposedly doing this action. He goes and files a complaint. He tries to plea it on up to the Supreme Court. And again, talking about that issue of being protected equally, no matter what state you're in. The Supreme Court chooses to pick up the case. The Supreme Court says, okay, just because you're in a state and you've committed a crime, you should still have that right to have that judge if you don't have the cash. His conviction actually gets overturned as a result of that. He's able to go free. There's another part of this. We get, again, more into these sort of discussions of proper legal procedure with my con law class, but there's also Witherspoon versus Illinois. So to go into a brief level of the courts, there's the prosecution and the defense, right? So the prosecution is the one that's trying to get the case to stick. The defense is the person that is saying, hey, I'm innocent of whatever, in most cases. So the prosecution is the one really trying to hammer on that this person was here and he or she did whatever act. When there is a case that has a jury, has anybody ever been summoned for jury duty? Not yet? No, you have? Okay. So it's a whole sort of idea that the case is representative of the person, of the accused, of the defense here. Back before 1968, various states had the ability for the prosecution to go and remove people from the jury that they felt weren't a good fit. So an example that happened at points would be you'd have, say, I don't know, a Hispanic American that was accused of a certain crime. You have an area that's pretty roughly balanced, say perhaps between white and Hispanic Americans, maybe someplace in Arizona, California, wherever have you. Well, the prosecution wants to showcase their case and have the best possible chance of winning the case. They want to be victorious here. They want to make sure this person goes away for 50 years or whatever the case might be. If you've got a jury challenge, you can point out and say, I don't feel this person's good. You're out of the jury pool. Now, the idea here is if you've got people that you can remove, why don't you remove people that are the same race as the person, the same age range as the person, that might understand, might be sympathetic for the plight of the person that's accused. So some prosecutions in some jurisdictions had unlimited ones of these. So they would go and essentially pick out the jury that's most in accordance with their viewpoint, would have the best possibility of going and really coming on strong to that person that's being accused. So you're probably not seeing anybody that's Hispanic. Maybe if it's a male, they get rid of a lot of the males. Maybe they get rid of a lot of the 18 to 25-year-olds. If it's some 19-year-old that's, I don't know, saying being accused of a joyride where he hit somebody. Maybe you get older people. Maybe you get white people, in the sense that they are really going to have a negative viewpoint of the person that's accused. Supreme Court weighs in and says, well, you can't just go and pick out everybody. There has to be kind of equality of these jury challenges. So if the prosecution has the ability to remove 5 people, well, the defense, the other side of it, should be able to remove 5 people as well. You can't just give the prosecution this leg up. So another protection that we have in regards to this, a jury of your peers, not just the jury that the prosecution wants to really be coming on hard for you as a defendant in whatever case that is. Another protection is a right to speedy trial. So this is an idea that things have to keep rolling along the process. They can't just forget about you sitting in whatever jail cell until they decide to get you in court. So that's going to be different based on the jurisdiction. You might see things have to be done every 30 days, every 60 days. But the protection here is that you aren't going to be, I don't know, in jail without any sort of movement on your case for 2 or 3 years. That's something to say that various things can't be appealed. There might be continuances based on a lack of information, things like that, but there has to be some movement. All right, so we'll do about 1 or 2 more slides here today. Let's get into the trial a little bit more. We did talk a bit about this illegally obtained evidence. So evidence that was brought forth perhaps as the local law enforcement not giving somebody the Miranda rights, that evidence was illegally obtained. If there is, say, material taken without a proper warrant being granted, that would be illegally obtained evidence. You can imagine if the courts were absolute in this regard, anything to further a prosecution's case against that defendant would be brought on in. Nothing stopping somebody like a sheriff's deputy from, I don't know, breaking into a gate and looking around somebody's house. There are protections here against that. The exclusionary rule is essentially, it says various evidence, if it's not grabbed, it's not gathered in the proper way, it can be removed from consideration in the case. And that is, even if it is showcasing within that the person's dead to rights, effectively that this piece of evidence right here showcases that this person was head of a criminal enterprise. If it's not been done properly, you cannot consider that as a jury. You cannot consider that as a judge if that's one of those cases. So when we get into the 1960s, it's a very stringent sort of interpretation that if you don't dot every I, you don't cross every T in regards to proper legal procedure, that stuff's removed immediately. Any sort of statement uttered before those Miranda rights, not able to be considered. Anything that is grabbed without a warrant cannot be considered. As a strict sort of way things operate. By the time we move into the 70s and 80s, this relaxes a little bit. What I mean with this is some evidence that traditionally would just be kicked to the curb starts to come on in, can start to be considered in the case where it's relevant. There's a bit of a change. There's a good reason for why this is. I talked about the composition of the court previously. If we look at the latter part of the 60s and into the 70s, and really into the early 80s, we get a lot of Republicans kind of running on a law and order sort of approach for their presidential campaigns. We're looking like Nixon, we're looking at early Reagan. And they're going to be appointing people to the Supreme Court that are more ideologically conservative, that are going to focus more on that law and order sort of approach. So we have a Supreme Court coming on in and kind of siding more with an increased police power. This ability to go and, if the police tried to do their best and just screwed up a little bit, we can bring in these facts to the case now. So two of these cases really matter. Hopefully none of you have had to look at a warrant, but the idea with the warrant is that there are specific requirements a law enforcement organization has to follow when they're granted a warrant. So they talk to the judge issues a warrant that has oftentimes a time and a place. So a specific amount of days, 2 weeks, a month, what have you. A place, it has a specific property, an address, 123 Fake Street or something like that. Now, just the reality of the situation in it, some police departments are that it's difficult, if not impossible, to get going on whatever case within that time frame. So if you are given, say, a week period, you're given a, I don't know, maybe you're given a warrant here on Tuesday or Wednesday, and you're given a 1 week warrant, say Tuesday. It might be kind of difficult to corral SWAT units, to get some other officers from other areas before the Labor Day weekend, to get all this sort of stuff done. What happens if those people come on in, say, Friday of next week? The warrant in that regard has expired. In the first period, any sort of evidence that people pick up from the execution of the warrant, even if it's scales and drugs, even if it's stolen materials, even if it's, I don't know, whatever it is, if it showcases that the person was guilty, back in the 1960s, that'd be all booted to the curb. U.S. versus Leon says, okay, the officers still did everything else by the book. They were a few days late. They still went to the right place. They still read, say, the Miranda rights. They did every other sort of protection there. We're going to allow them to bring in that case. We're going to have them be able to bring in whatever scales, whatever drugs, whatever they picked up in that specific example, even though technically in a previous time it would have been excluded. There's another one of these called the inevitable discovery exception, where other information can be brought on in. So you can imagine here, I live on a place that I rent out a house. So it's got a specific address to it. The person owns property in the back of that address that is not at that address. They own like an additional acre or two. The idea here is that perhaps if they're trying to find something, the warrant gets issued for that actual address, the domicile, and they're deciding to go in that back part of the property, despite the fact that if you look at a map of Magnolia, the property might end, I don't know, 3,000 feet behind the property, like the actual house itself. But they find evidence of whatever illegal activity a quarter mile behind that. The same guy owns the same area. That evidence can be brought into a court case as well, despite the fact that strictly it's not at that address. It's at a different parcel of land entirely. It's kind of inevitable. It's going to happen because the person walking through with flashlights or whatever, they find whatever bad material they're looking for. Again, in that first period, it's kicked out. It's not considered. In the 80s and beyond, it's allowed to be considered now. So this is a change that's went on. So greater amounts of police power in regards to the evidence that is ultimately considered. So this actually continues through to the 2000s. Obviously, everybody has heard of, recalls, wherever you're at with this with 9/11. So that obviously happens. We lose 3,000 American citizens as a result of it. There's the thing called the Patriot Act that Congress releases like September 17th, like 6 days afterwards. Part of what it does is further increase police power. There are things like warrantless wiretaps. So in regards to cell phone communications, that passive collection of cell phone data is allowed, where previously that would require a warrant that gets granted to that law enforcement for a specific line. Now that sort of data can be collected by police agencies. There's other issues as well, that if somebody is a purported terrorist or affiliating with those sort of elements, that things like a car tap can occur. There was a big example of an individual that, if anybody's ever used Reddit, Reddit at the time had, took a picture underneath his car of this weird device. And what ultimately they figured out was local law enforcement stuck a tracker onto the guy's car. Absolutely a constitutional usage of the increased police power under the Patriot Act. There was no warrant needed for that. So this sort of thing that begins in the 1980s has continued through till today as well. So the sheer amount of information that's brought forth that can be considered in a court case is a lot greater than that really restricted period back in the 1960s. Final slide here, and then I think we'll be able to call it. We're looking at the 8th Amendment, and this is the cruel and unusual punishment amendment. It's one of the most challenging sort of things that we'll look at in regards to how the Supreme Court has weighed in upon. And let me explain why that matters. What is cruel and unusual? So if we look at how the Supreme Court has weighed in time and time again, they have not explicitly had a case talking about the death penalty and its legality, its constitutionality. Standards have changed over time about what is cruel and unusual in regards to punishment for crimes. So in a number of states 100 years back, hanging was a proper way to do it. If you go back to, say, the French Revolution, you're all familiar with the guillotine. Other places and other points, there's been drawing and quartering people, which would be essentially to tie somebody's appendage to each of 4 horses and smack them on the posterior until something happened. Back in the day with Greece, there was a punishment that people would be lashed to a boat, fed honey, and just forced to lay there until the bugs ate them. We can obviously and quite easily say a lot of those are pretty cruel and unusual. But in a number of states, or excuse me, in a number of states, I mean in a number of countries, people have determined the death penalty is absolutely cruel and unusual. Even though the Supreme Court has not weighed in upon the legality of the death penalty generally, we have noticed the Supreme Court has said some things about what can be done in terms of giving people the death penalty. So the first of these talks about the people that don't have higher mental reasoning. Individuals under the age of 18, so minors here, and those people that might have a mental disability. Each of those, the Supreme Court has weighed in and says, okay, if the people are under the age of 18 or have been shown by a medical professional to have a severe mental impairment, you cannot give them the death penalty. You can easily give them life in prison. That's fine. But you can't take away their life. So before we get too much further with this, can somebody help me out here? What's a 3 strikes law? Yes?
3 felonies and life in prison.
Yeah, so we've got a number of states that have a 3 strikes law, exactly as being said. If you have been adjudicated guilty of 3 felonies, then it's an automatic requirement that you spend your entire life in prison. Which a lot of people, again, at the surface level, okay, if you've been convicted of 3 felonies, maybe you are unable to be rehabbed. If you look deeper at it, it becomes kind of problematic, right? So there's an issue of time frame. People live 80, 90, up to 100 years. There's a chance that, well, maybe you ran pretty wild back in your teens and 20s, and you did some nasty things. Maybe you end up not having any sort of pension by the time you get 60 or 70. And you decide, okay, it's a pretty dire situation. I'm going to steal something big and sell it just so I have enough money to eat. You cross over into grand theft. It might be $500, it might be $1,000. You get adjudicated to something that it's still a crime. You might have had a spotless record for 50 or 60 years. The law would indicate that now you are forced to live the rest of your life in prison. And the laws differ between states about which of the crimes, which of the felonies really matter. Some it's violent felonies, but sometimes it is just any sort of felonies. And again, the issue there is the felonies can all be different. I think a lot of people would agree with the fact that if you've grievously assaulted somebody a bunch of times, if you killed somebody, perhaps something like a lifetime in jail without parole is a decent punishment. But there are a lot of things that are felonies that end up really not maybe making muster for locking people up. So there's some problems with that as well. All right, so we're going to finish up. This is the end of the lecture. I want to showcase what we're going to talk about on Tuesday. We're going to complete our discussions here about Chapter 4. So we got appeal, we got some issues of racial profiling, and then some rights during war. What I need people to do for this next class, for Tuesday, read through about the first half of Chapter 5. That's the Civil Rights chapter. It's going to talk about various populations in the United States. So women, African Americans, Hispanic Americans, Native Americans.